Welcome back, everybody. Panel 4 is Evidence and Research Review, Data Trends and Gaps in the Context of Children in Conflict with the Law. The moderator for this panel is Dr. Siva Prasad Yellasiri, who is an IPS officer of the 2011 batch from the Sikkim cadre. He completed his MBBS and later earned an MD in Forensic Medicine and Toxicology from AIIMS, New Delhi. In 2007, he served as Superintendent of Police in Namchi, East Sikkim, Gangtok, and Pakyong districts. He was given the Governor's Award on Doctors' Day in 2021 for his efforts in fight against COVID-19. He also received the Governor's Award for Public Service in 2024 for his continued contributions to public service. In March 2024, he joined SVPNPA as an assistant director and currently holds the position of deputy director administration. The panelists on today's panel are Mr. Shashidhar Shetty, Member Secretary, Karnataka State Legal Services Authority. Sir is a district judge and the Member Secretary of the Karnataka State Legal Services Authority. He began his legal career practicing as an advocate in Kundapur and Udupi in 1995. Appointed as a civil judge in 2003, he was later promoted to senior civil judge and served as deputy director at the Karnataka Judicial Academy. Elevated as a district judge in 2017, he has served in Bangalore and Belagavi. He previously served as member secretary KSLSA from 2020 to 2022 and as Registrar of the Supreme Court of India from September 2022 to January 2025. He is currently serving as Member Secretary, KSLSA, for a second term. Ms. Nayanika Singhal is a Senior Researcher Associate with the IJR. She has an MA in Criminology and Justice from TIS Mumbai and is a lawyer by training. She has researched on the criminal justice system in various capacities and has been associated with the India Justice Report since 2019. Ms. Yamina Rizvi is a lawyer specializing in child rights. She is a senior program officer at iProbono India, where she leads the juvenile justice vertical, offering pro bono legal representation to children in conflict with law. Her work focuses on research, advocacy, and litigation support around children in conflict with law. So I would request you to...
Yeah. Okay. Thank you so much for introducing the panel. Good morning, ladies and gentlemen. Let me also extend a warm welcome to our distinguished panelists and also the participants to this panel discussion on evidence and research review, data trends, gaps in the context of children in conflict with law. At the outset, I have to say I'm very overwhelmed and humbled by the presence of Justice Lokur. During our probation, that was in the year 2012, Sir was the Honorable Chief Justice of United Andhra Pradesh High Court, and Sir visited Academy a couple of times, and Sir, it's a great motivation to all of us. Thank you, sir. Well, I call this session a more scientific session. This panel is about discussing the evidences, the facts, the data gaps, trends, and the challenges in gathering data. And we will look at the available, what the available data tells us about children in conflict with law, what it doesn't tell us, and why these missing pieces are important when decisions are made about children, their rights, and the future in the justice system. Well, we all know data is crucial, as no policy or law can be effectively designed or implemented without credible evidence. When it comes to children in conflict with law, there is limited data available in the public domain. Most important resource we often use is Crime India report. The latest report which we have is of the year 2023. Even that report has a lag period of more than 1 year. If you need authentic, credible, reliable, latest data from state agencies, I feel it's a blind spot. I think even this Crime India report talks about the registered cases, the registered FIRs, but we believe the problem is much bigger. And we also have another great resource in this area, that's India Justice Report. I think one of the panelists is going to talk about that. And the research is happening elsewhere, like by individual researchers, civil society organizations. Well, to address this gap, today's panel bring together the practitioners working directly with the children in conflict with law. One of the panelists is from Karnataka State Legal Services Authority, is a member secretary. And we have two panelists from the civil society organization. They will share data and insights gathered through their own work, offering different perspectives from the justice system and also the field. Well, now I would request Shri Shashidhar Shetty ji from Karnataka State Legal Services Authority to share his thoughts.
Good afternoon. Honorable Justice Madan Lokul, former Judge, Supreme Court of India. Honorable Justice Sunildat Yadav, the Judge, High Court of Karnataka and Chairman of JJ Committee, Karnataka, learned panelists here and all the delegates. Since I am from Legal Source Authority background, I will just concentrate much on legal services lack in the legal aid and the problems and gaps and what are the improvements that we can make. So legal aid or legal services, according to me, legal aid is a narrow definition, whereas legal services is a comprehensive everything under section 2 clause 1 clause C of the Legal Services Authorities Act. The legal service rendering of the services in the conduct of the case or any other legal proceedings before any court, tribunal or authority, and also providing advice in any matter. As you all know, Section 2C clearly mandates that every child is entitled to legal services. Juvenile legal representation must function within a child-centric framework, prioritizing protection, participation, and rehabilitation. Present challenges which we see, the mindset of the functionaries under the JJ Act. There are so many involved in the under the JJ Act. If you take up from the starting point, when the child comes in first contact of the system, from the SJPU, that is a special juvenile police unit, then the court, JJB, CWC, and children court, and also after child care institutions. A lot of discussion has happened with regard to the negatives, what is happening in the court, everything is right. But how to work out? So because what is there, it is there. So we are not legislators. So legislature has to take that call, or we can make a recommendation for the amendment, or we can challenge it before the court. But how to work out in the existing system, that is very important, and we have to focus on that. That's why I said to change the mindset of everyone. As far as judicial officers are concerned, I can say that they are working in other courts, the criminal courts, various courts, and they have no idea about the child psychology and other things. So it is our duty as to train them and tell them what is required to be done under the JJ Act. It's a separate entail, and choosing the principal magistrates while posting them in the JJ board, it's also very important. High Court has to take call on that and see that such persons who are fit to that post, they should be posted. Then legal aid often provided only at later stages. So it should be ensured at the initial point of apprehension. Legal aid practice commonly limited to securing bail and the trial or inquiry before the JJB or the children's court, JJB proceeding remain adjudication centric. Legal assistance often terminates with the conclusion of inquiry and limited extension to rehabilitation and integration as in spite of section 39 and 40 of JJ Act. Juvenile justice principles, legal process ignoring these differences risk converting vulnerability into criminalization. I know that an incident that happened in Bangalore about 6-7 years back. A child was apprehended for committing theft as a 15 years old boy, and unfortunately bail was rejected by the JJB. He was Kalpana Purushottam madam was, I think, was a member then, and she knows about that. The child was sent to their home. The poor mother came there and she came in contact with an advocate who demanded for 6,000 rupees. She had no money. She went back and after 8 days, she came back, paid the money, got the bail. And do you know how she got that money? She sent her elder son to commit theft and got that money and paid the fee. So this is the real fact which we have to counter, we have to see. That's why I said that early intervention is very much required. Otherwise, they will be again criminalized in our system. Legal aid occupies a central role in ensuring child is not merely represented, child is meaningfully protected throughout the judicial process. Without effective legal aid, procedural safeguards under juvenile justice remain illusory. It is also an incident that happened in panel advocate we depute in the legal service clinic. In Bangalore, one panel advocate, it is a 6-7 years old incident when Justice M.G. Uma Madam was the member secretary of state authority. So that panel advocate was there for continuously for 4 years or 5 years. So he had a good rapport in that system, including the staff, everyone there. So he started getting money, collecting money from everyone there who are coming, the parents, guardian and all. So that was complained to the state authority and he was removed immediately. But 60 to 70% of the cases was with him. So that was very challenging for us also to how to take it out back to the legal aid system. So that we should be very careful. The legal aid panel advocate should be changed off frequently. That should not be continuous for years together. The legal aid concept, the traditional concept is not applicable when we consider the juveniles. The child requires guided participation, protection against coercion, assistance in understanding consequences of proceedings, facilitation of access to rehabilitative services. Extended legal aid and legal aid includes immediate access to counsel upon apprehension. That's why I said pre-arrest stage or pre-apprehension stage, the child should provided the legal service or the legal aid which required to him. Protection against illegal detention and coercion interrogation. That is also very, very important. Even today, the police apprehends and they produce before the JJB. In 2022, an incident happened. Myself and Honorable Justice Sujata, then chairman of the JJ committee, we did a surprise visit to the observation home at Madiwala, Bengaluru, and we found a boy in the observation home, a single boy, aged about 17 years, and his condition was pathetic. There were bruises on his face, and he could not walk also. Then when we asked him, he said, police beaten up me. So then I took him to corner, and when I inquired him, he revealed that the observation in the ground floor, in the first floor, there was place of safety. There were 4 or 5 boys, the elder one. So they came down in the night after 12 o'clock. The security guard opened the gate, iron gate is there. So he opened up and he allowed those children to enter inside the observation, and those boys beaten up this young boy badly. And immediately in the JJ committee, we took up that issue, and the place of safety was changed and shifted to KGF. So this is one thing where we have to take care. The superintendent was not staying there. The staff are not, because if you see the staff who are deputed in the observation home, they have one or the other departmental inquiry, some complaints. So the persons who are already in trouble, they are posted in observation home. That is one area which we have to look into. Child-friendly explanation, legal rights and process, advocacy for bail and non-custodial measures under Section 12 So yesterday we were discussing about the payment of surety amount. So now, in view of the judgment of the Honorable Supreme Court in Satyendra Kumar Antil case, poor prisoner scheme is introduced. So if it is the government duty now, if the prisoner is a poor, then government has to deposit that surety amount up to 1 lakh. And the empowered committee in the district level will decide that. If it is above 1 lakh, then it will come to the state level committee. So we are telling our legal aid councils to look into this issue, and they have to extend this benefit to those poor prisoners. And so surety amount, whatever may be that, it is the duty of the government. There is a separate fund from the central government, and DC of the every district has to pay that. And the representation during preliminary assessment is very, very crucial. This is where we are lacking. Even if there is an order, a mechanical order, PA order by the JJ board, it is not being challenged. And before under 101, that is also there. So we are sensitizing our legal aid defense council to do that. Then legal services, legal aid to child in legal services, the role of legal service institution or JJB, CWC or child care institution or children court is encompassed in Juvenile Justice Act and Karnataka State Juvenile Justice Rules 2025. I must thank Swagatra and her team for finalizing this rule in Karnataka. Very beautifully, more than 28 sections or rules are there, which tells about the intervention of the legal service authority and the role of every institution under the JJ Act, how they have to implement the Act, provide legal services at early stage. And it is actually the duty of the juvenile justice police. Once the child is apprehended, immediately an intimation given to the jurisdiction DLSA to provide legal services, but it is not happening. So we have to sensitize them. Even under Rule 10, there is a provision which says that once the preliminary assessment order is passed by the board, it is a duty of the board to tell the child or its parents that they have the right to appeal against that order and they have the right to free legal aid. Again, if the case comes to the children court, again it is the duty of the children's court to tell that the child has the right to file appeal and to get the legal aid, and the children's court should wait till that appeal is filed by the child. So there are several such provisions, so I don't go in elaborate. Then at another point is final report. It is being taken up in every juvenile justice committee meeting. Under Rule 10(6), it is the duty of the investigating authority to file the final report within 2 months of from the date of the apprehension. But in 2024, figure says that out of 3,060 cases, in 524 cases, the final report was not filed even after 2 years. And in 2025, also we have more than 219 such cases. And under Section 165 BSA, the process of courts in obtaining necessary documents, ensuring evidence is not withheld while safeguarding the sensitive government communications. It is the JJ board has to look into that aspect. Further, under Rule 10(7), during inquiry, the board shall use its power under Section 165 of the Evidence Act. Then legal service to children, Nalsar scheme is there, which tells about the establishment of legal service unit for children, that is LSUC in every district, and providing legal services to in the police station, JJB, CCI, place of safety, then CNCPs in family-based care, then child witness, children for adoption, child victims of crime, children involved in custody and guardianship, and then legal service to police station for at the police station for the missing and trafficked children, and so on. And one important point which I highlight, that the compensation, in the previous session also it was discussed. I have seen in the last 4 or 5 years, no order by the principal magistrates awarding victim compensation. We have so many such orders from the other courts, criminal courts or the DLSA, but there is no such order. It is very, very important to highlight, and we are sensitizing our judges to look into this aspect, and otherwise it is a really injustice to the children or the victim. And Rule 10 clearly says that it is the duty of the CWC and DLSA to ensure that the fine amount imposed by the court is being paid to the victim. So in Karnataka, the Legal Aid Defense Council is handling 442 cases Out of that, 213 cases are disposed in 2025 and 229 are pending. The 5 years old, 4 years old cases are pending. And when we ask the Juvenile Justice Board what is the reason, they say that the child is irregular or witness is absent, SHO is failed to secure the witness, IO not attending the hear, prosecution has failed to secure the witness in time, and child is migrated to another state, like that. So these are the reasons they stated. Of course, we are monitoring the work of the DLSA councils. And we have 34 JJBs in Karnataka. We have 30 districts, but 34 JJBs, and 2,770 cases. Legal assistance were given by our advocates. That's a panel advocate. So
That's thank you so much, sir, for sharing your thoughts on legal services available. And I was just going through the India Justice Report. I think Karnataka is a better performing state as far as the indicators are concerned. So compliment all those from Karnataka, because the report actually ranks the states based on the performance. I think Sikkim is also doing really good, how many members are there in the JJ board and all. So we'll come to the statistics. I think now I'll invite Ms. Nayanika Singhal to share the data and evidences.
Is this visible to everyone? Should I start? Good afternoon, everyone. It's a tremendous honor to be here with all the experts and practitioners in the field of child rights. I'm Nayanika. I will be speaking about the India Justice Report. And actually, India Justice Report's very specialized report on juvenile justice and capacity at the front lines. As Sir mentioned, and as for people who may not be aware, that the India Justice Report assesses states across 4 pillars, which is the police, prisons, judiciary, and legal aid. And it is based only on hard government data and not perception. We assess capacity of the states on how well they are equipped to deliver justice to everyone. And it is on the basis of this framework that the special report on juvenile justice also follows, is the same methodology, and the assessment of states to understand whether the states are equipped enough to provide justice and to provide, are capacitated enough to provide justice to children in conflict with law. The study basically focuses on whether the states have the capacity to deliver justice as per the mandates laid down in the JJ Act of 2015. Our methodology for this report was, and I'm going to be very quick, our methodology for this report was purely RTI based. It was a year-long RTI based assessment because, as we are all aware, there's no central repository, no complete central repository of data of the institutions that make up the JJ system. So we wanted to assess whether the elaborate dedicated system that has been laid down in the statute is actually working on the ground, where children experience it directly. And as we all heard in the discussions yesterday, or data, rather the lack of it, is one of the major findings of this report. As you can see on this slide, that we filed the applications to all states and to 4 state agencies, namely the WCD, the SLSA, the police headquarters, and the State Child Protection Society. 11% of it was rejected, 24% did not respond. So the fact that there is no data, or rather there is a lack of manpower to maybe collect data, is a major finding of this report. Right. Continuing with the theme of there is no data, I would very quickly take you through the findings of our report. Firstly, we looked at whether every district in the states had a juvenile justice board, and as you can see, 707 JJBs in 765 districts, which is about 92%, did have a juvenile justice board. There were a few states like Telangana and Andhra Pradesh that did not have. Like Telangana has 10 JJBs across its 33 districts. Andhra Pradesh has 13 across its 26 districts. But on the other hand of the scale, you can see Karnataka and Odisha, like Sir mentioned, Karnataka has more JJBs. But however, just because that there is a JJB doesn't mean that it's functioning fully. While there were principal magistrates in place, most places, most JJBs had an appointed principal magistrate. Where the vacancies were, and they were large in number, was in the positions of social workers. 24% of the JJBs functioned without a full bench as of 2023. I'm sorry, I forgot to mention that the period of the study of our report was November 2022 to October 23. What we found was that where social workers were missing was especially in a place like Delhi that has 7 JJBs that should have had 14 social workers, but had only 7, so which had a 50% vacancy. There were several JJBs that were obviously fully constituted, but vacancies where there were because of missing social workers. Now, where there is a JJB, and we all know, as Justice Nagratna also mentioned yesterday, that all JJBs don't really sit routinely. They don't sit every day. It has, and obviously with large vacancies, it has a direct effect on the functioning of the JJB, which obviously leads to delays and pendency. We assessed the JJBs and their workload. This was a first-time exercise that anybody had conducted. And because the data was so sketchy, so patchy, we received data on caseload from 362 JJBs. And we found that about more than 50,000 cases were pending as of 2023. The total workload of these 362 JJBs was about 1 lakh, and about half of that was pending. And pendency ranged from 83% in Odisha to 21% in Mizoram. Now, as Sir was also talking about the lack of legal representation, this is something that our study has also found. We also assessed whether there were a legal aid clinic attached to every JJB, as they are supposed to be. And of the 400 odd JJBs that responded to this question, there were only 305 clinics attached to them. Now the first 6 bars that you see in blue, I don't know whether it's clear to everybody, but the first 6 bars are the first 6 states that told us that they have a legal aid clinic attached to every with every JJB. But the Manipur and Nagaland told us that they had no clinics attached. We also asked a question related to whether there was specialized lawyers available with these JJBs, and as we've been hearing over the past 2 days, there really aren't, and that has come out in our report as well. If you want more details about the legal aid bit of it, you can please refer to the yellow report in your kits. It has everything. Right, moving on. Another very important finding of the report was that the probation system is absolutely overwhelmed. Because, well, they have a lot of workload, but there are major vacancies. Again, the disclaimer is that this is the data point on which states responded to us. So we see that Goa reported no probation officer, while Himachal Pradesh, Mizoram, Odisha, and Sikkim had a LCPO in every district. Overall, of the 10 states that did reply to us on this data point, it comes out that their workload comes out to about 175 cases or children per LCPO, which is a huge workload. Coming back to the structural deficits, which is in the children's homes, the observation homes, the special homes, and the places of safety. We received almost no response related to this when we had asked the question basically on physical infrastructure, but our RTI applications were actually rejected on privacy, mostly privacy concern, citing privacy concerns. Yeah. Now, as per the Act, there's supposed to be one observation home per district or one in each district, a group of districts, I'm sorry. Most of all, overall, we found that most states have an observation home for a group of districts, which is, however, those observation homes have about only 60% of them have a person in charge. 80% reported that there was no doctor. Now, I'm sure that the doctors are being brought in by the district government hospitals, but we're not sure. And there was a terrible lack of mental health experts that, as always, has been pointed out also. There were no places of safety in 14 states, which is a concern. Obviously, because if there are no places of safety, then they're obviously probably being placed in adult jails. We also found that there were homes that were combined, which Sir was also mentioning that it's harmful to be placing children in observation home as well as in places of safety. Right. Now, this is an interesting cut of the data that we had done. We received proper full information from just 292 districts across the 765 districts that we reached out to. Now, the biggest circle says that we reached out to 765 districts. We received sufficient data from 292 districts. 100 of those districts met all the 7 criteria on the right, which is how many SJPUs do you have, how many JJBs, whether there is a legal aid clinic, etc. And when we really get down to the data, out of these 292, only 11 districts report that they've met all the criteria. And 8 of these were in Mizoram. So that just kind of paints a picture of what the infrastructure looks across the country. I'm going to end here, and I'm going to let others talk now.
Very, very interesting data. Thank you so much. I mean, I think I must compliment Nayanika and her team to, for preparing such a wonderful report. And also, there is some satisfaction in the statistics. Sikkim finds a place everywhere, like the membership and even the childcare institutions and all the pendency rate as well. So now I would request Ms. Yamina Rizvi to share her data and findings.
Thank you so much, sir. Hi, everyone. My name is Yamina Rizvi. I will be presenting 3 major issues that we worked on. The idea of presenting 3 major issues is to highlight the data trends, because the topic is data trend, and we want to see that what are the trends, and most importantly, what are the challenges that we are facing when we are talking about the data, because yesterday there was so much of conversation around where is the data. So we are all organizations, there are journalists sitting, and we all know how difficult it is to get data. So we want to shed some light on the challenges primarily. But before that, we'll just go ahead with some of the research that we have engaged in. All right. So iProbono has primarily engaged on three main issues. One is children incarcerated in jail. One is pendency in the JGB. And last is the preliminary assessment reports that we've analyzed. So let's start with the first one. What we did was we collected data from all the jails to understand that how many children are getting transferred from jails every year. It was a detailed study for a period starting from 2016 to 2021. And we asked two questions. One was regarding that how many children are getting transferred, and second was regarding that how many visits are being done by the JGB members to actually identify children. The data was, of course, startling as expected. Only 50% we received in terms of reply, because again, this is an RTI study, so not all the states replied to us. There were a lot of limitations, but we received only 50% states reply. And in that reply also, the total number that came was more than 10,000. Of course, the number was very alarming. Post this, Nalsar also put out one report, which highlighted that in a period of 1 year only, there were more than 7,000, which was the number in terms of children who were in jail. It also asked that how many applications were filed, and that only 20% were filed. So that is again an alarming problem, and it's a continuing problem. It's not like that after this situation became better. It still continues to be, and probably there's a need to keep engaging on this issue more. So that was the first data point that we collected. I'll come to the challenges a little later. The second RTI study that we undertook, and we are relying a lot on RTI because again, there is no other source through which we can get data. This was regarding the pendency in the JGB, and we strictly focused on Delhi this time. We wanted to understand two things. First was to understand the level of pendency, how many cases are pending. The statutory timelines, if we know, is 6 months for all the cases to get over. Of course, for serious and heinous offenses, we know that there has to be permission sought from the CJM, etc. So for the second thing that we wanted to understand was whether the review mechanisms or the Act provides safeguard in terms of countering this pendency. Are those being also followed? Are those mechanisms actually working? So when we did this, so the numbers that we got was that more than 2,000 cases were pending for more than 6 months. It's a total number. There were more than 190, to be specific, 206 petty offenses cases, which were pending for more than 6 months. Now I'll just highlight over here that Delhi in 2019, Delhi High Court passed a judgment where it said that the cases that have been pending for more than 6 months should be automatically terminated, and they did this once for 600 cases altogether. So there is a precedent in Delhi for that. But despite that, subsequent report shows that petty offenses continue to be there for more than 6 months as well. For of course, you will see that for other offenses, you will see that more than 300 cases have been pending for more than 5 years. There are 2 cases which are pending for more than 10 years. We also need to emphasize enough on this fact that we often think that only petty offenses need to get over within 6 months, but for serious and heinous offense, it's fine. Whereas the law doesn't expect that. It's an exception which is given that only if they're not able to complete that within 6 months, then they have to take a permission, and only then they can proceed with the further proceedings. So far in Delhi, there's no practice of seeking this permission from the CJM or CMM. Nobody is asking. The JGBs are continuing even after 6 months. In all of the cases that we represent, we are facing the same problem that the cases have been pending for 3 years or 4 years before the JGB. Although the boy is out on bail, but the case is still pending. There is one case who we are representing has been in the system for 8 years right now. And he has gotten his life settled, earning, got settled, married, kid, everything. But he's still coming on each day for the date of hearing. And he talks about it that, no, I will never have a normal life because this is going to continue forever. He has no hope from the system. Now, instances like these are not just one, there are so many around it also. What we wanted to highlight that this particular provision that you have to take permission has to be used little more. What has started happening now in Delhi very recently, and Mr. Asthana shared actually one of the orders that he also got, is where we started moving an application that you take a permission from the CJM and CMM before proceeding further in the case. And some of the Juvenile Justice Board principal magistrates have been kind enough to actually do that. But the second problem that comes along with that is that the CJM and CMM doesn't know whether they have to do it on the judicial side or an administrative side, and how are they supposed to proceed with it. So that's another challenge that we have to see, because there are no guiding notes as to on what basis they're supposed to decide whether to give that permission or not to give that permission. So that's another problem that is pending, and one has to look at it. Then Another thing that we also asked for in section 16, if you see, it talks about that every quarter there has to be a report sent from the JJP to the CMM again to look at the pendency and also give recommendations as to how to counter that pendency. Again, a review mechanism to see that there is no pendency. We asked all the 11 districts this question. Only one said that yes, we received the data and we give recommendations. They never shared the recommendation, but they do share. They said that they do share recommendations and we take it on face of it. The remaining 10 told us that no data comes to us from JGB, or if they come to us, we have never given recommendations. Now, it's a very important provision to look at, because to counter pendency, if these functionings are not happening, then the pendency will keep on growing. So that's the second point. The third point that we filed was regarding high-level committee. If you see, section 16 talks about high-level committee. It says that there's going to be high-level committee which is going to look into the pendency. They will also receive data. Again, in Delhi for past 3 years, the committee was not functioning. Thankfully, it has started functioning now. They had a couple of meetings and they're coming up with directions. And one positive change that has come for it is that now there is a JGB 7, which is putting out the data on their softboard in terms of what is the level of pendency. So that's one positive change that came out of that. And we, of course, filed this petition in Delhi High Court also. So JGC has also passed a couple of recommendations around this as well. The next thing that we did, so of course, the previous two were based on RTI. So what we wanted to do is delve a little into the qualitative part of it. And we thought that we'll look at the information that we have, because we represent a lot of children. So we have a lot of PAs with us. So we picked 18 PAs to just see what are the patterns over there. What are the challenges that we are seeing in those particular PA reports? Of course, we did this assessment on two things. One is, of course, section 15. The 3 guidelines that section 15 tell us: mental, physical capacity, consequence and circumstances. I'm not going to go because we've talked enough about it. And of course, in the light of judgments that have come. So Barun Chandra, Durga Meena, and the NCPCR guidelines that are out to assess whether all those 18 PA reports that we have are meeting the standards laid down by these judgments and the NCPCR guidelines. The major findings that we got from that is all the preliminary assessment reports, all record the confession of the child as is. And I know a lot of people have talked about it already, but this is just coming, and this information is also there on the website. We've done specific case studies, so we can go a little more into detail if anybody wants to engage in that. So each of the PA report records the confession as is under the circumstances heading. It says verbatim and it records everything. In terms of mental capacity, the understanding of all the PA reports is that if there is no intellectual disability, that means the person has the mental ability and therefore understands. They are very limited to 2 things. They don't show remote and any sort of remorse or guilt, and they don't have any sort of mental disability, therefore they understand. With respect to understanding of consequences, what they have divided is 2 questions that they ask: cause and effect, whether the child understands the future. There are PA reports which talks about that because the child had the weapon with him, therefore he understands the cause and effect. There are PA reports which mention because the child is taking active part in the observation home in vocational activities, therefore he understands about his future, therefore the consequences. He has the understanding to understand his consequences also. And that's how they are going into long-term and short-term consequences. There's no conversation, or there is no conversation with the child also to understand anything with respect to long-term consequence. The conversation will always be limited to how the offense was committed, who were the people with you, where did you find the knife, where did you hide the knife, how did you do it, who told you to do it. All of those. So it looks more like an interrogation session more than a document which talks about the assessment in terms of whether the child has that understanding also in terms of long-term, what Barun Chandra talks about, whether the child knows the impact in terms of his own family, the family of the victim, etc. None of those conversations are there. One interesting thing that we saw in Delhi is that there is a specific segment on legal history. So of course we have the 3 parameters: mental, physical capacity, consequence, and the circumstances. There is a 4th column, which is D column, and that asks for legal history. Now that column lists down what were the previous offenses. Was he convicted in that offenses? The nature of the offense. I am not sure where is that particular thing coming from and what is that trying to establish, apart from, of course, a certain narrative, but it doesn't have any legal sanction, so to say. I am not a mental health expert, so I don't know how much that is helpful, but I don't find that any mention in the law in that terms. Some of the specific anecdotes that I would like to share is there are cases where there are a couple of boys involved. So if one FIR has 2 or 3 boys, what they do is they pass one common order saying, spoken to the boy, all of them should be transferred. They do not understand that each boy can have a different mental capacity, each boy can have different circumstances from they are coming. There will be one order. If there are 2 separate orders also, which we are challenging in one of our cases, they are verbatim same. So it will just say CCLR, CCLK, the entire text is going to be same, with no difference in a single word. So there is no application of mind being done when it comes to the orders of the JGBs as well. When we also saw that there was this one particular case that we have where he's alleged to have committed 2 offenses on the same night. So at 11 and at 2, he's committed 2 offense murders. The FIRs are of 2 different areas. One preliminary assessment was conducted. The first FIR in that the JGB has transferred the child to the children's court. The second JGB for the second FIR has not transferred the child to the children's court. That also shows that how subjective it is, and there is so much of risk of arbitrariness coming into picture. Because for one same PA, for one same boy, for the same night, for 2 different offenses, 2 different JGBs have come up with a very different conclusions. That also shows it's very individual. It depends on the training of each judge also, and of course, whatever biases that comes along with that judge. So that's also something which is very alarming. The orders that come with respect to preliminary assessment, they have only 2 things. One, the absolute reliance and belief in the PA report. There is no questioning of the PA report. There will be just statements saying that, assess the PA report, it says so and so, the child has the mental capacity, the child understands the consequence, and the prosecution says that the offense was committed in so and so manner. Of course, the prosecution's argument is going to be completely based on nature of offense and how the offense was committed, nothing beyond that. In terms of argument from the counsel of the CCL, it's going to be that he opposed. And that's it. It ends. Very often there are no observations with respect to 2 of the elements also. It would be child has a mental capacity, therefore transfer. It won't even talk about the other 2 elements that are there. So that's what we are dealing with. And this is a state which has very less percentage of children being transferred. It's Delhi that we are talking about. Other states have a larger number of children being transferred, and in Delhi, where things are still better, we still have this situation going on. So just for us to look at how alarming the situation is. The challenges, I'll just take 1 minute to finish this. What are the challenges that we are facing while collecting all of this data? One, there is no information available with respect to CCL, which is state-wise, district-wise, or at a macro level in the public domain. For example, National Data Judicial Grid. We talk about that a lot in terms of talking about pendency. But we know Delhi has still not been able to put up data with respect to juvenile justice. When we moved to the High Court said, in one of the replies, the JGB has informed that there is going to be an all-court meeting that is going to be held, all judges meeting, and post that, they will put that data out. So that is one thing that is going to happen at some point of time. Not sure when, but it'll happen is the promise that we've received. So that platform. Other platform in terms of everybody at that point of time in 2015 talk about from the side of the lawmakers that this is something that is needed. But nobody actually assessed that, has it actually worked? 10 years down the line, has this led to any change in the crime rate in terms of, has it helped anybody? If you're not talking about society, you're not talking about children, has it helped the society in any way? So that has also not been looked into. Second thing, confidentiality. A lot of us struggle, even as lawyers also, a lot of us struggle in getting paperwork and getting any information in the name of confidentiality. Every time when we want to get data on this issue, we are told, no, it's confidentiality, juvenile justice, no information available. But the idea of confidentiality is just to hide the identity of that one child. It is not to remove the entire data from the system so that there is no accountability. So that is something that needs to be looked at. Third, lack of awareness. When we file any sort of RTIs, half of the time people don't know that they are that authority. So for example, when we asked in different courts in Delhi and in other places that how many children's court are there which are functioning, they transfer that under the Juvenile Justice Act, they transfer that application to the JJB because juvenile justice term has been written, so they don't know their children's court. They transfer it to the JJB to answer that question for them, how many children's court are there. How many cases are pending? Again, they don't know because they think because juvenile justice is written, so send it back to JJB. So they transfer the application back to JJB. Then we call the person and tell him, no, sir, you have to do it because it's here. So then Almit will collect somehow the information and do it. Same goes when we file application with the CJM and CMM. Similar situation. They didn't know that they were supposed to get this information in the first place. So there is lack of awareness around the issue. Then comes denial of information through or incorrect information. Very often, and we've talked about this earlier as well, that RTI is not the most reliable tool that we have in terms of the accuracy of the data. But unfortunately, there's no other tool available to us through which we can get data. Of course, we can use this as representative number, but not the exact numbers to which we can rely on. There are also tools that are being used in terms of denying information. One thing that we very often hear back is that confidentiality, of course. Second thing we hear is that the information does not exist in the format you ask for, even though we give in the bottom that any other format, but the information is not given. Then somebody told us that what we do, madam, is when first RTI comes, we deny the thing. Half of the people then don't file RTI, so jobs become easier because it's too much of a work for us to give all that information. So denial of information becomes a very big problem. I will stop here. Way forward, we can discuss a little later.
Yes.
Thank you so much for your
questions, right? Yeah, thank you so much, Yamina ji, right, for sharing your thoughts and sharing the challenges that we face in getting the authentic and reliable data, especially from the state authorities. First, I'll pose some questions to each of the panelists. Then we'll take some questions from the participants. Let me ask you a question. So you spoke about this legal services authority, you shared your experiences. In the absence of a consolidated good data, how difficult does it become to supervise the functioning of key actors like police, probation officers, JJ boards, and childcare institutions?
Definitely, it is a challenge because every time we have to ask from the police department or from the DWCD. So now in Karnataka, we have JJ portal. So recently we have implemented that as per the direction of the JJ committee. And we are collating the data and putting it there, and we are connecting it to the various other stakeholders. So that is the one more improvement that we have done. Of course, according to me, the data should be there. Of course, identity has to be concealed. That is there under the Act. It is a provision. But I think there is nothing wrong in putting the data. So that is we are working out.
And just to add, what kind of data would you like, which would help in proper ensuring proper accountability and quality of interventions with regards to children in conflict with law?
So far as legal aid is concerned.
Yeah.
Yeah. So the legal service authority, we have our own mechanism. The DLS, district legal service authorities are there. They are providing the data. That is only on paper. So it is not on this one. They electronically, they are not transferring the data. Insofar as the other departments, because there are so many other stakeholders. So the SJPU is there. There is the CWC is there. So for that, we have to again depend upon the other departments. We have to call for data from various other departments. It is not only legal service authority. To act upon in the field, to provide the legal service, there are other stakeholders. The rule says that once the SJPU apprehends a minor, immediately an information has to be sent to the DLSA. It is not coming. So that is to be done by all the stakeholders. That's what I mean.
Okay.
So not only one department.
So I was basically wondering what sort of data which would help us in doing micro data. I would say, like, one, you have the broad numbers, about the how many cases are there, how many bails are there. That's one aspect. And a micro data, like, further going deeper into this data. So what would kind of help, the authorities to have a proper control? So I think maybe we'll come back again. Now I have a question for Nayanika. You have done a great job in collecting the data. And I think that also has a lag period, I believe so. And just to add certain things, there's districts are more, and there are less number of JJBs, especially you said Telangana and AP. I think after that there has been reorganization of the state, both the Telangana and Andhra Pradesh. The number of districts have increased from 13 to 25 in the state of Andhra Pradesh, and in Telangana also I think it has become 31. So earlier 10 districts were there. So that's how, still maybe now if you ask them through RTI, so the reply might be different.
Hopefully, yes. We did find a few notifications that that said that there have been JJBs set up, at least, or are in the process of being set up, which I did not mention in the presentation. But yes, they are in the process of working through it.
And this Child Care Juvenile Justice Act, this is more of a state subject, and states are the implementing agencies. But then, what challenges you face, and how does this variation in implementation of these things across the states, the inequities, how does it affect the national level understanding of things?
I think what really is missing because of the lack of data is a lack of supervision of the authorities and the agencies who are working within the JJ system. For example, we had also asked about how many JJBs are going out and inspecting the childcare institutions, and that data has also been quite poor. I mean, there have been new digital interventions that have come up, but I think what has happened is that there has been no monitoring of the justice, of the judicial, of institutions that make the JJ system. Yeah.
Well, one question to you. Based on your findings, you also collected a lot of data. What immediate policy or procedural changes would you think most appropriate to improve compliance with the JJ Act?
I think our understanding of juvenile justice is, we are yet to explore Juvenile Justice Act entirely. We are limited by certain provision on which we are focusing a lot, but there are provisions which are for the welfare also. And if we can start looking at those and using to the best advantage of the child. For example, the provision I just told about, in terms of after 6 months for serious and heinous offense, you have to take permission. There are many lawyers sitting here. How many of us have been filing applications to move to the CJM or CMM to take those permissions? And if not, why is that not being done? Is it coming from a lack of awareness? Probably just pushing the system at the right place, using the right provision can be very helpful. Similarly, using bodies like HPC, High Power Committee, are they functioning in your respective states? Are they actually doing the accountability that they're supposed to do? Are those cases that are pending for a very long period of time? What is being done in respect to see how to reduce those pendencies? Why are the DMs not evaluating? The law talks about the DM will have to evaluate all the JJBs regularly. There are no evaluation reports coming out. Why are those things not being done? Because if we start doing those, then something is going to come on record. The data that we are talking about constantly, maybe filing those applications and asking constantly for some sort of replies will go a long way in bringing a lot more accountability in a very non-transparent system. So I think that's one thing that we can do. Thank you.
Well, before we close, so we'll take some questions from the audience. Yeah, Ajay. Okay.
Hi, my name is Anuti. My question is directed at Nayanika. I just wanted to understand, when we'd seen IJR's report when it was released a few months ago, I work with Tular, by the way. So we wanted to understand, is there a certain reason as to why the data on POs was not collected? Not legal cum probation officers, I'm talking about POs, just POs, and because they're really integral part of the whole system.
Yeah, that I would say that is a limitation of our report. We did not ask questions on probation officers. We asked only on the legal cum probation officers. Yeah.
Thank you. My name is Valay. I work at the India Justice Report. One of the things that we also measured, which is we've not deliberated on in the last 1.5 days, is the fiscal priority that we give to child protection sector. What is the money that we are putting in for our children's protection? And so I just want to mention those quickly. Out of the entire union budget, we allocated 0.03%. Huck did this analysis for years, budgets for justice, and this we need to continue to look at that. That's one. So that's about 1,500 crores. Once double-decker flyover in Delhi is going to cost around 1,500 crores. And this is the entire union budget's allocation towards it. Unfortunately, the state budget documents do not disaggregate. This is in the report. You can look at page number 60. The state budget documents do not disaggregate allocations made towards either child protection, as in CNCP or CCL. Therefore, we cannot fully enumerate what is each state putting towards child protection, JJBs, observation homes, so on and so forth. So that is also something that is a recommendation that we all can make to WCD in our respective states, that the department itself should ask the finance department to start disaggregating this data. So therefore, then we can have probably more arguments, and the argument is there, but we can advocate for it. Under section 105, I think, of the JJ Act, the JJ fund has to be created. Our friends here, everybody probably knows that, but that is something that we have kind of given up on for various reasons, and probably good reasons or bad reasons. Each person has their own opinion on it. But this JJ fund also is not being utilized very well across different states. It's a whole variation. Some states may be doing better than others, but the range is from 5 lakhs to 5 crores to, in some states, 1 lakh and then even 10,000 rupees for this fund, which was, I suppose, created for the express purpose of giving the department and the institution some liberty in how to expend money towards child protection. So just wanted to add this to Nayanika's presentation, which we left out because of the time issue. Thank you.
An important point you raised, funding. I think we haven't spoken about the statistic with respect to funding. I think I was also reading the same thing. 1,500 crores is allocated, but there is a silver lining. The same report says that there is 8% increase from the previous year. So, but then I think a lot of funding has to be there. I think I see a link between the funding and also a lot of vacancies in the JJ boards, right? And I think funding has to be there for even the childcare institutions, and also that's where I find that's a weak link. So we have to do something on that area. Yeah, you want to add something?
Yeah, I just want to add something to what Valay has said. Apart from the funding that is there for the JJ system, there are other areas, where the legal services authorities have to provide funds. For example, in POXO cases, right? In acid attack cases. So there are many of these, so when you're looking at budgeting, it's only a suggestion. When you're looking at budgeting, please take that into consideration. I had an experience once about a 13 or 14-year-old girl in Chandigarh who had been raped and she was pregnant, and she was not given the some amount that was due to her. And I asked the member secretary of the Chandigarh Legal Services Authority that why is it that you're not dispersing that amount to her? And he said there are two reasons. One is she's 33 in the queue, so I have to meet the demands of the first 32. And the second reason he gave was that even for these 32, I don't have money. So when her turn will come, He says, I have absolutely no idea. So this is just in addition to what Valay has said, and try and look into it if you can. Thank you.
Hello,
Hi.
sir.
Thank you, sir.
Hello, sir.
Okay.
Hi, sir.
Yes,
Yeah, you can come in,
Yeah.
please. Yeah.
I am
Then
Dr.
I'll come
Phillips
back.
from Hyderabad. I represent an organization called Divya Disha. Fantastic actually to look at data coming in. How important data is. One small suggestion for both the agencies that have done this data. Here we are struggling with lack of data. And one of the biggest players, the SLSAs and the JJCs, have a role. Unfortunately, the SLSAs and JJCs do not have a template. Is it possible? You very rightly said. When we are looking at JJ Act, we are looking at 1, 2, 3, 4, and that's it. Either we are very busy, obsessed with CNCP, and we totally ignore child in conflict with law, and there are so many provisions. Nobody knows whether it's operational in terms of systematic structures, in terms of procedures. It's important to be able to come up with a dashboard. And perhaps this dashboards could be used both by the JJCs, and SLSAs are mandated to look at the JJ implementation. But somewhere these two agencies as watchdog, as somebody to overseeing agencies, somewhere the data will have to be there at some place. Today, if we are at a situation where we need RTIs, it also shows to the penury in the system. That means we are doing so much, we are talking so much, but data is not present in one places. To begin with, JJCs and SLSAs are good enough for us. Can we begin, and can both the agencies look at creating dashboards? And more importantly, also in terms of, because many provisions are there, like look at the review mechanisms. Review mechanisms ought to happen both at the DC level or at the CMM level. Nobody seems to be doing. At some stage, the SLSAs have the mandate to be able to call it out, call for reviews regularly, because they have the power to do that. So, and I think, how about actually looking at that, and also both the agencies can look at pro bono as well as also India Justice Report. Fantastic work that you people have done. It's very heartening to see. I think when Justice Lokar was a CJ in Telangana, in Andhra, those days we had actually done up a status report on JJ implementation in Andhra Pradesh those days. It served as a starting point for us. But I think we need data continuously being brought in, and I think he brought it very well in terms of somewhere funding will also have to be part of the discussion. Personnel, funding, without that implementation to that level. Now the biggest catchword is ask CSR. My question is, child protection is mandated. Okay, so I think.
If I could just
Hello, sir.
very quickly come in here for Sir's point, where you're talking about templates for collation of data. In our RTI exercise, we did find a few good templates. For example, the Madhya Pradesh JJC has a dashboard that puts out data very regularly on the cases that are pending and the cases that have that are with the JJB at the JJBs, which is, I think, is a very good practice, which I'm sure now Karnataka is also coming out with a portal. So I mean, as Sir was also saying that data, it becomes a blind spot, but here I would say that data is a low hanging fruit, just an opportunity to be just taken advantage of. Yeah.
Hi, good afternoon. My name is Aishwarya. I'm a I'm a research assistant at Nalsar. I wanted to know if, while iProbono and India Justice Report has been collecting like lot of data, like on through RTI basis, was there any data with respect to Section 24 with respect to removal of disqualification after the expiry of appeal for the CCLs with respect to JJB and the Children's Court as well? If there is any, I just would want to know if there is not any. I mean, why is that process not being done? Because yesterday also, I think his name was Osama, right? He pointed out that I've not been able to apply to certain jobs because, I have to tick that I'm criminal throughout my life. So I just wanted to know if there is any, why data with respect to what is being done with Section 24 implementation. Yeah.
We have not collected any data around it. But from our own experience, we have to actually move an application before the court to say that now the case is over, please remove the records. Of course, for cases that are, I'll tell you a very interesting case. There's one case which was transferred to Children's Court. JJB, preliminary assessment done, moved to the Children's Court. Children's Court found the child to be, acquitted the child. Now the question arises whether the data is going to stay or not. Because the law says when you're tried as an adult, then 24, the benefit that you get under 24 doesn't apply to you. How do you deal with that? So we also, as I said, we're yet to explore a lot more provisions from the Juvenile Justice Act because we don't know answer to these questions. The Children's Court did not remove that data. It still exists because they said that that provision is not going to apply to us in terms of removal. So they acquitted the boy, but the data still exists. So I don't know the direct, in terms of any data do we have? No, we don't have data, but we have experiences from our case. We have to move application very often and police still shows the record. There was a boy who wanted some job application and that his entire thing came up. So we have to get it recorded in the JJB order itself very often.
Good afternoon,
Yeah,
sir.
we have good afternoon. This with respect to the suggestion which the sir has made. I would like to submit that with the able guidance of our Honorable JJC High Court of Karnataka and at our registry level, we have made necessary steps to collect the data regarding the JJ boards functioning and the orders which are being passed by the children courts and our KSLSA, Karnataka State Legal Service Authority. To that portal also, we are trying to link that JJC and all the JJ boards database. So hopefully we will work on it very soon and thank you for the suggestions. Same is taken note of, sir. We will work on it. Thank you. Sir,
Okay, can someone pass the mic to him?
sir, I have mic. I have a question.
Okay, we'll take that question first because he's been raising hand the last 10 minutes.
Thank you, sir. My name is Krishna Sharma. I'm from Assam. I'm a lawyer by profession. I have one question to the panelists as well as everyone present here. With more and more data reports coming in, it has become very important to how to read this data. Because at times the data which comes on the report, we miss out the nuances of those data. Suppose if we are talking about funding, which is a very important part. But when we go on the ground and we get to see, given that the fund doesn't come in April and end on March, it come by the September or November and you have the fund get lapsed by the March. This is what my understanding being on the ground. So then there have been joint signatories and there are a lot of bureaucracy and administrative difficulties that come in picture. So with more and more data on everything that is coming in, I think IJR and iProbono have done really well on bringing out this issue at first place. But anyone can suggest me how to read out because at times people get too much swayed away with the data of the big number, but we misses out on the minute details and what's happening behind. So my question is that how do we read the data? How do we understand this data and what are we missing out something before we address the actual problems? Thank you.
There's just one word of one word answer to this actually to understand and to read nuances. It's context. We all know the context of which of where we stand, of what child rights is, and how there is a lack of data. So whenever we do have any amount of data that is coming in, it is very important to ground it in reality, and then ground it in reality of the area of where the data is coming from. That would be my submission.
Just to add to her, it also depends on, where are you placed actually. If I'm a police officer, I would be looking at certain data. If, childcare institution, they would be looking at, certain data. So if you're a lawyer, I think you will be, that's how I think we'll have to. So it also depends on in the cycle, in the chain, where you are, what stakeholding you are doing. So that's how I think. But this is the basic data. I think once the basic data comes, analysis also would come in the, you know.
Sir, I have two questions. One is specifically addressed to Shetty, sir. Sir, when the matter of a legal aid lawyer, where the child has been given legal aid representation, it goes in appeal, be it children's court or in high court. There is no linkage between the lawyer and the child. And especially in JJ, rather than criminal justice law, we'll need more of a facts and story of the child to be, addressed to the court. So, is there anything which can be done to the appellate arguing lawyer has a direct connection with the Caesar's family then also? Because in Delhi, we do have a provision. I am in the legal high court committee. I've been empowered to visit the observation home, and then I draft the appeal. So I know what is there to argue, and I've met the child. But I think in other states, this provision is not there. If something can be done.
Yes, in High Court, we have High Court Legal Services Committee panel is there, panel advocates, and also pro bono advocates. There is a list of pro bono advocates. Of course, there is a problem in connecting this JJ board or the children's court with the High Court. So that we have to look into. There should be in the JJ portal, we can make a mechanism wherein immediately when an order is passed, that should be intimated to the High Court Legal Services Committee. So they can take up the matter and provide the legal aid immediately.
Yeah. And the second question was with Shiva sir. Sir, is there any linkage between DCPU and SJPU? Because all of these JJ fund, which is because I used to apply an application when the attendance of a juvenile is dispensed at JJB. The cost of traveling with the parents, we used to apply for an application, 2,000 has been paid for visiting from Bihar to Delhi JJB. And that was immediately given to the child and the family from the JJC fund because I have written immediately. So instead of CNCP, for CCLs, this fund was more utilized. So if there, because the JJ fund is at the dispense of DCPU. So if there is a linkage there, if that, is there something like this or if it can be done?
Someone,
Sir,
is someone answering her question? Right?
Not really like part of the JJ fund or any other fund. So it's the DCPUs or the probation officers, they have that fund and the money is given from there. So Delhi, we have that provision. But now since
I think she wants the link between special
No.
juvenile police unit, district child protection officer
no, that link.
per unit. Okay.
So they operate in different fields. Obviously, the linkages are there because we talk about convergence and everything. But directly, there is no linkage between the SJPU and the DCPU, even where the question of funds is concerned. Okay, now, but since I have the mic, I'm just going to make one or two more small points. I have several points on this data, but I am just going to make a couple of points. So one thing I want to say, like you have data about the observation homes in every district. See, somewhere, I mean, I may go against what everybody believes. I'm not very worried about having one OHB in every district. The reason is that some districts have very few children, so it may not be very nice to have just one or two children in an observation home. But the thing that worries me more is that I have come across instances where the children's home and the OHB are in one compound. So have you tried to distinguish whether it's an OHB and whether and whether there's a segregation based on the age in the OHBs? Because again, I've come across observation homes where even a child who's like 7 years and a child who's like 16 years, that they are staying together. Okay, so one is that. Secondly, it was about the data about like the cases which are pending. So you said there are certain cases which are 5 years old or 10 years old and all. So have we actually done some study, like got deeper into it to find out whether from institution itself they are in JJBs, so they are 8 years, 10 years old, or whether it is because they were transferred from the adult courts and so that is why they are older cases. Okay, so.
Sir, I'm Ashutosh, as child protection consultant based in Jaipur, Rajasthan. In her inaugural address, Justice Nagaratna talked about mediation, use of mediation in matters of children. And my question is to Member Secretary, Karnataka State Legal Services Authority. Do you think legal services authorities are suitably placed to take initiative of mediation, using mediation in resolving matters of children? Because you have empaneled mediators across like all over country, you have mediators. and it's a constitutional permanent body. And if you start, like, this initiative can be started in any part of India, and maybe setting examples for entire nation. So this is my submission.
In the mediation, whatever the
Last question. That was the last
conversation
question before we
going
close.
on between the child and the social worker or the anybody, so that will be confidential. So in mediation also, the mediation process, whatever the discussion going on between the mediator and the party, that will be kept confidential. It will not be put before the court. The same thing we can do in the JJ PA report also. So the whatever the child discloses, it should be kept confidential. It is not necessary that we should place it before the board. If it is favorable to the child, then only we can. So we can filter it. Nothing wrong in that. But child should be, and the parents of the or the guardian, they should be. We have to discuss in the mediation process. Everyone will be included. So we can try it. It's a good suggestion. Definitely.
Thank you so much. I think the session is more about data analysis, evidence. See, yeah.
Many states have not you don't have data from. Could you connect with somebody from that state, a voluntary organization, to collect the data and send it to you all? You know, to continue with this report, so that you cover entire, the whole country and collate the data.
That is
Just
not
to,
Yeah.
I think they started in 2019. If I'm,
no, we
Achha, this you.
yeah.
Okay, sorry. So, this is the first time you are giving that report.
Yes, yes. On JJ, yes.
I found on net another India Justice report.
Oh, that is our,
Okay,
that is our
right.
flagship
If you want to
report.
answer that question, please.
We actually, that is not an approach that we did, but that is certainly a learning that we had while doing this exercise. What we did was we approached the state institution directly in trying to follow up with them and trying to get them to answer the question that we had, and we had some success on that front, but we did not approach civil society organizations to follow it up for us. Yeah.
I think there are only two ways of getting data. One is like the government itself, the agencies, they put out the data, like, and collated, and the crime report that is published by the National Crime Records Bureau. And the second one, I think, is the application of RTI. You apply, right? So wait for the agency to respond. Sir? I think this is from the previous presentation. No. Okay, I think we have exceeded the time limit given to us by 10 minutes. So I would like to thank all the panelists. Just to summarize, I think we had a great discussion. I think data is the best medicine for policy reforms and initiatives. I feel research itself is a very challenging thing, very painful thing. At Academy, we are trying to do some research on some topics related to crime. Collecting data is real challenging, but you agencies, your organizations have done a wonderful job. Some important things like research on funding and all, I think that's one area which needs to be addressed. And and a lot of suggestions have come from the participants. Thank you so much. Best wishes to everyone. Thank you. Especially, I would like to thank Justice Lokur sir for patiently sitting through the this session. Thank you. Thank you, everyone.